you so much for staying on and staying glued to Stackers TV. How you all doing out there? Of course, it's another beautiful weekend. I mean, whenever it's Friday, we always jump up, enjoy and say, oh, thank God it's Friday. And this goes specifically to most of the people that are working, because if you are not working, why are you thanking God it's Friday? Okay, so yes, welcome, good evening, and welcome to a legal program. This is Regnum Legal Education and Evangelistic Program. And as you all know, we are back fully and we are here to educate you, to guide you, legally, all the legal matters you have, and some of them you don't really have or know how to handle them. This program is here to make sure that you align or you find yourself, the solutions to your legal issues. I mean, I'm talking about individuals, organization, groups, and so on and so forth. It has to do with legal matters. So welcome. Thank you so much for joining us this evening. My name is Joy Dambo. Wherever you're watching us from, please tell a friend to tell a friend that Starcross TV is live and we are here to discuss legal matters. My name is Joy Dambo once again, if I already did. And of course, I can't do this program alone. I don't even do anything here. All I do is to make sure that the legal practitioners give you all the information you need when it has to do with legal matters. So join me as I welcome, of course, our ever consistent guest speakers here in the studio who are always here, day, night, in short, anytime you call on them, they are always here. Join me as I welcome Barrister Kenneth Itorobase all the way from Akwa Ibom. He's always coming all the way from Akwa Ibom to be here on this program. We really appreciate it. Good evening, sir.
Yes, thank you. Good evening.
You're smiling
Good
very
evening,
well today.
viewers. Yes, we are happy.
No, I can see
In
that.
Akwa Ibom, it's happy hour every Friday.
Oh, I see.
Happy,
I see
yes,
there is
so-
something that is making
Yes,
you
so
happy
we are
evening.
always happy.
Okay. So what is this happy hour like? What do they really do?
It's a time, according to the governor, the newly sworn in governor.
Okay.
It's a time to get all Akwa Ibomites to relax.
To relax.
Yes, so
Just sit at home
so
and
we
relax. So is it that you guys work or you don't work on Fridays?
We work on Fridays, but from 4 p.m.
Okay, from
the
4 p.m.
happy hours begin. So
Alright.
that you not cheat government.
Okay, so
Yes.
we are still in your happy hour moment. Sorry about that. I'm sure you will enjoy it next week.
Yes.
All right, welcome. Good evening. How are you doing today? How are you doing today, sir?
I'm fine.
Okay.
Yes.
Welcome.
Yes.
Yeah, sitting next to him, of course, is Barrister Osim, Roland Osim. Good
Thank
evening,
you.
sir.
Good evening too.
How are you doing?
I'm fine.
I noticed there is something about whenever you're putting on your glasses and whenever you're not. So today you appear very simple and very I don't know the right words to use.
Well,
but whenever
yes.
you're putting on your glasses, you're always very serious in that lawyer's
Exactly.
mood.
Today,
Just like Barrister
today I
Kenneth.
feel like I should relax.
Relax.
Because this morning I've been walking and overworking myself.
So that you have joined the happy hour.
Even the talking today
It's gonna
will
be
be
minimal.
gradually. and I
Okay.
pray our governor should equally replicate the happy hour to our
In
state.
cross-river states, right? Of course. Everybody deserves happiness in one way or the other. We deserve happiness. Anyways, thank you so much. You're all welcome to our program as
Thank
always.
you.
And just in case you're joining us, and those of you that have not been following up on our program, today is another edition of the Regnum program, and it is a continuation of what we discussed last 2 weeks, and we want to bring it back again because we had a part 1, so this is the part 2 of our previous discussion. So our topic of discuss was an appraisal of the determination of contract of employment. Yes, that was the topic of discuss last 2 weeks. So this week, sorry we couldn't come up last week because of the the Women's Week was enormous, and it was really packed filled with so many activities. So we had to skip 1 week, just to be here again and allow the women, to enjoy the glory and of course all the special moments and treats Starcross gives to all fellowships. So thank you so much for joining us again today. We want to talk about another issue, which has to do with an appraisal of the determination of contract of employment. I think we last talked about what employment is, what contract is, and so on and so forth. So just quickly before we go into details of today's discussion, because today we are not going to waste your time, we're just going to go straight to the point and give you, digest this topic into your brain. For those of you that employ people, employ staff, you need to know, you need to sit tight and listen, because these are for employers, if I'm not mistaken. Exactly. So, yeah, so Barrister Kenneth, can you please quickly give us a rundown, just a brief intro about this topic once again before we go to part 2 proper?
Yeah, like the topic implies, is an appraisal of the determination of contracts of employment. And under that topic, we looked at what the contract of employment is. We tried to look at the types of contract of employment. So in order not to waste our time, we had taken the first 3 kinds of contracts of employment, which I spoke about: the divine contract of service, and then I talked about the public service contracts, and then I talked about the traditional master-servant relationship.
Yeah.
Now today we are going to look at contract for services. Remember, the other one was contract for service. This one is a contract for services.
Okay.
And in order not to take our time, a contract for service is an independent service contract for a fee. So for instance, the person that built this house was involved in a contract for service, as opposed to a contract for service. This is a contract for service as opposed to a contract of service. Under the contract of service, we looked at the public service contract, where I said there was presumption of job security, where the only thing that can get you out of that job is your own misconduct, which is spelled out under the public service rules or the rules book in case of a private company. But here is a contract for services, where it is the business, it's a business-to-business contract, an independent contractor and a self-employed person. You call him and you tell him, I want a 2-bedroom flat. You show him the land.
Yeah.
He brings the costs, and then you give him the funds. He prepares a 2-bedroom flat to your taste. Once he finishes that, his contract with you is finished.
Yeah.
So now a contract for service agreement usually contain the following important clauses. We have the state how long the services are needed, include the location.
Yeah.
Like I said, you show him the land where the work or services are to be rendered, describe the work to be done. For instance, if the building is already complete, you will say you want what do you call it?
Scaffold.
No, it's painting.
Painting,
You said
yeah.
you want painting, describe the type of paint that you want, and the person does the painting and it's over. That's a contract for service. And then we talk about, you outline the remuneration and compensation when he finishes the job, and then you state the terms and conditions of the agreement, including the mode of termination. For instance, you can say, once you finish painting and I pay you, we are done. Sometimes the agreement can now say that we will keep looking at the painting for a year. If it doesn't fade off, that is when the contract determines. So it depends on what both of you will agree, because they can say, okay, we finish painting, we wait for 6 months. We will pay you half of the remuneration, the compensation. When after 6 months, if the paint does not peel off or fade, we will give you the balance. And then 7, have the agreement executed to ensure you can put your pens to paper to ensure that nobody cheats the other. You understand that kind of circumstance? So that is for a contract for service. Now there is a contract of apprenticeship. Contracts of apprenticeship are for children, persons that are below the age of 16. And everything that is expected to be done under the apprenticeship is governed by the Labour Act. It is the Labour Act that regulates. I think section 49 to 51 of the Labour Act regulates contracts of apprenticeship under Nigerian situation. But in other places, there may be other legislation that regulate it. But here it is, the person has to be under the age of 16, and it has to be a contract of apprenticeship, that is a contract of training. You are training the person to fit into the model of the circumstance. So if the person is learning computer, if he's learning football, He will, when he leaves that contract of apprenticeship, is when he will fit in as a footballer. He will fit in as a computer operator. So under that age of 16, it is a contract of apprenticeship, and like I said, the Labor Act from section 49 to section 51 regulates that contract. So maybe I should give my colleague the opportunity to also say something.
Okay, of course. That's why you both are here, to always say something. And this topic of discourse is a very important one, which all of your opinions will be very, very necessary and important. So I would like to ask Barrister Hossein, because by my question here, I want to ask him, what constitutes the formation and structure of contract of service?
Thank you so much. Generally, contract of employment are governed by the general principles of contract. That is to say, the principle of contract are equally applicable to the general contract of employment.
Okay.
Now, for you to have a successful binding and legal contract, there must be this element involved. To me, I also used to say it is the ingredient. It is just like somebody, you are asked to prepare a dish, a soup, let me say so, this delicious dish. And if you fail to include some ingredient in it, that will not be palatable. So now, when you talk of contract of employment, you have these elements and principles. And they are: one, we have offer and acceptance. Two, we have consideration. Three, we have legal capacity to enter into contract. Four, we have intention to create legal relationship. And then five, we have the contract must not be contrary to public policy. Now let us take it one after the other. When we talk about offer, an offer is being made by a party to another party. So it is defined as a promise made by one party to the other with the intention that it becomes binding on the maker if it becomes accepted by the offeror, the offeree. That is to say, you are making this offer to somebody, and you have that intention that if this offer is being accepted by the other person, it should be binding on you. So that is the definition of offer. Then, when you talk of acceptance on the other way, acceptance is the reciprocal or an action of the offeree to which indicate his acceptance of the offer as being conveyed to him by the offeror. Now, I mentioned offeree and offeror. So what is offeror and what is offeree? Offeror is a person who offers a promise to the other person. And then the offeree is a person who accepts that offer. Now, in a contract, there must be this meeting of minds. The two persons, the one who is offering and the one who is accepting, they must have agreement. And that is called in law consensus addendum. That is, both parties have agreed to execute a particular agreement. Now we move to the next one, which is consideration. Now, when
I thought the legal capacity comes before consideration.
You can
take them.
Okay,
because I was waiting for that legal capacity.
Yes, I'm coming to that.
To me, before he goes into the second aspect of it, because we were looking at the universality of these issues, so we always brought in the Labor Act. So now under the Labor Act.
Yes. Sorry. Sorry. Let me take it. I forgot that.
Let him.
Under the Labor Act, Section 7 of Labor Act stipulate that the employer should give to the employee a written particulars of the employment within 3 months of the employment. Whereas the employee should also accept the employment by undergoing medical examination, among others.
Okay.
That is stipulated in Section 8 of the Labor Act.
Okay.
Then we move to consideration. Consideration, that is the basis of the contract. That is the payment, the favor,
favors,
what you take home, your salary, or the benefit you earn as a worker. Now it is also known as the quid pro quo.
Okay.
The quid pro quo, that is to say the favor which you gain from the employment. Now, consideration, even an apprentice is entitled to consideration. You must have to give him a little allowance, even though he is still an apprentice. So now we move to the next one, which is legal capacity to enter into contract.
Okay.
Now, in contract of employment, the common law stipulate that you must, that infant, lunatics, and
persons of unsound mind.
Yes, persons of unsound mind and chronic drunks, they don't have capacity to enter into contract.
Okay.
Yes, they cannot enter into contract.
Okay, so you can never go to into any contract with these people.
Yes, you cannot
And
go
if
into
you do,
contract
it's
of
on
employment.
You. Yeah.
It is of employment, not for sales of goods. Because if it is sales of goods, they will tell you for that they can go for necessaries.
Okay.
You understand?
Okay.
You can buy something and eat. You know, because you must survive. But when it is for employment, you cannot employ an unsound mind somebody. Cannot employ a lunatic.
Yeah.
Cannot employ anybody below the age of 16. Then the Labor Act stipulates that people under the age of 16 years cannot contract cannot go into contract of employment. It is only for apprenticeship. Yes, somebody below the age of 16 can go for contract of apprentice, can be an apprentice, but not to work as a full-time staff of a company or wherever. Now, we move to legal relation, intention to create legal relationship.
Yes.
Under intention to create legal relationship, it is presumed that any contract between a husband and a wife is not legally binding.
Okay.
It is called domestic contract or domestic agreement.
Okay.
So for a contract to be legally binding, it must create that legal intention. For instance, in the case of Balfour versus Balfour, where a Briton promised the wife that he's going to pay the wife £30 every month. At the end of the day, he could not fulfill the promise.
Yes.
So the wife now took action against him for specific performance. Then the court held that there was no legal intention created in that contract. It is just a contract for honor. Then also another case of Spellman versus Spellman. The same, the husband promised the wife that he's going to buy her a car. At the end of the day, the car actually arrived. Instead of him transferring the car to the wife, he refused to transfer the car to the wife. So the wife became angry and took action against him. And the court said no, that there's no legal intention to create any legal relationship. Then also we have, the next one is contract not being contrary to public policy. You know, if there is any contract that is illegal, it is void ab initio. That's to say, from beginning, there is no contract. For instance, if a student enters into a contract with a lecturer in the school to say, sir, because of I'm not too brilliant, so please I want you to assist me I'm going to pay you so certain amount of money, so that you continue to pass me until the day I'm going to graduate in this school. Now the man will take the money, maybe they sign a contract down. At the end of the day, if the man fails to fulfill his promise, you cannot take him to anywhere, because that contract is void ab initio. From beginning, there was no contract.
Okay. So now, before you can have those kind of contract, that means a lawyer should be involved. Is that what you're saying?
A lawyer can be involved. A lawyer may not be involved, because a contract, whatever both of you put down, which is, and then you put it in a way that it creates a legal intention. There's no need for a lawyer to be there or not. It is the intention you have that you have put down. It is binding. But the reason why we have these other contracts which are not binding, like when we are talking under this category of creating legal relationship, there are three categories of contract. One, we have domestic and social contract. Those are the ones I earlier spoke on, concerning the husband and the wife, and also a pastor and a church. Yes, those are social and domestic. Then we also have another category of contract, which is commercial contract. Those ones are the ones like you are going for employment, you have capacity, you have all it takes to, work under that contract. So you can enter into such a contract. Now those ones are binding, except where there are exception clauses. There are some contracts that there are some clauses that will tell you they exclude themselves from it being binding on them. So those ones are the only ones that, when it is on commercial contract, that it cannot be binding on the other party. Then we also have another category of that same creating of legal intention, which is called intermediate contract. In this one, it is just like a group of persons will agree, maybe parents will agree to, contribute money to a particular person who will be fueling his vehicle to take the children to school every day. Now, if it is my turn today, I pay, and it is done. It is the other person's turn, he pays. When he now get to Bro Kenneth's turn, he says he doesn't have money to pay.
It's not in my character.
No, yes, I'm just using you as an example.
Yeah.
And then by the time he says he doesn't have money, such contract is not binding. Yes, because there's no legal intention to legal relationship.
Well, let me add to that so that we can move to something else. You see, when we talk about capacity to contract, it has to do with the law. Like he has rightly stated. For instance, under the public service rules, because the public service rules is what regulates all other kinds of contracts. Under the public service rules and under the Labor Act, you find out that capacity to contract is limited to a person of 18 years. If the person is 18, he can be employed in government or any other establishment. But below 17, the person is still seen as a dwelling capax, that he does not have the capacity to contract. You understand? Now, when the person does not have the capacity, he will be treated as an apprentice. Although the law protects the apprentice, like I said, under section 49 to 51 of the Labor Act, there are a set of rules and regulations up to 53 of the Labor Act. There are a set of rules and regulations that are reeled out for the protection of the young person, that is the apprentice. You understand? But the full contract, he cannot go into it. And then on the other hand, when it comes to intention to create a legal relationship, you will remember that on this very topic, on the last time, we discussed when it comes to a divine contract of service. When we talked about humanitarian and social contracts, just like he mentioned one social contract, which is that of a husband and wife, we will also mention another social contract, which is that of serving God. You understand? That is between a clergyman and his church, and said that those contracts do not have the intention of creating any legal relationship, because the court will not be able, under the circumstance, to determine or differentiate between a commercial relationship That is a purely business relationship and a social relationship. You understand? Yes. Under intention to create legal relationship. And now when it comes to public policy, whether the contract is illegal or whether it's contrary to public policy, I just want to give you an example. In the last 8 years, there was a ban on import of Tokumbo vehicles into Nigeria. Yeah. Now let's assume that Sister Joy Dambo sells Tokumbo vehicles, and Barrister Osim and Barrister Kenneth want to go and buy Tokumbo vehicles from Sister Osim, and then we entered into an agreement for the delivery of a fairly used Corolla, a Toyota Corolla 213 model, and then Sister Joy Dambo appended the signature on that agreement, and then went in, brought a Toyota Corolla, or maybe she didn't even bring the Toyota Corolla, and then she came into Nigeria, and then where is our Toyota Corolla? And she said customs have seized it. I don't know if you understand. Yes, you understanding
that
now?
One is none of your business.
Now, me and Osim decided to sue Sister Dambo, yes, for the supply of the 213 model fairly used Toyota Corollas. You know, because there was a ban on the importation of Tokumbo vehicles, that contract becomes illegal, okay, and contrary to public policy. Okay. So at the end of the day, once it gets to court, the first issue that will be canvassed is whether that contract was legal under the Lex Fori, which is the law of Nigeria. Once it is found out that it was not legal, what the court will do is to strike it out. Okay. That is what we are trying to say, that for all this, for a contract to be valid, all these elements which he has mentioned, offer and acceptance, consideration, intention to create legal relationship, yeah, capacity, and then it must not be contrary to public policy. It must not be an illegal contract. Okay. So if all these things are not complete, there is no meeting of the minds. It becomes incoherent on one point or the other. Let's assume that we now go and realize that Sister Joy Dambo is 16 years or 16 and a half years. You know, she looks older than that, but when she brings her birth certificate, she was 16 and a half or 17. You understand? So we now see her that she was a minor as at the time she entered into that contract. You see, all this goes to vitiate. It becomes a vitiating element of that contract. That is exactly what also happens in the contracts of employment. Okay.
Thank you very much. I also want to know, so what are the obligations of the employer and the employee in a contract employment? What are their obligations?
Yeah, you want to talk about duties. When we talk about the obligations, it has the duties. For instance, it is the duty of the employer to provide work. Okay. He has to provide work. So if you employ a person, the law assumes that you have the job to give the person to perform. You understand? Now, if you look at Section 17 of the Labor Act, that the employer is bound to provide work, and when for any reason he is unable to provide work, then he is bound to pay the employee for every day he has failed to provide work. You understand? So it is the duty of the employer to provide work. There are, however, some exceptions to that rule, so where the employee is entitled to overtime. If we are talking about overtime now, for instance, you are working now. If, for instance, you are working since morning and your time stopped by 6, now it is overtime. And now your employer calls you out here to come and perform Regnum legal program, and then at the end of the day, Regnum did not hold today. He is entitled to pay you for the overtime. You understand? Really? He is entitled to pay you for the overtime. But if he had provided the work, you understand, and you come in to do the work, he is entitled to pay for the overtime. But let's look at the situation that when you came in, he now said Regnum is not holding today. Sorry, let's get it right. If at the end of the day you came in for the Regnum program, and then he informed you by 6:30 that Regnum is not holding today, he is only entitled to pay you for the 30 minutes from 6 o'clock, which your normal work finished. Okay. He is not entitled to pay for the 2 hours which you were supposed to stay till 8:30. Okay. You understand? Okay. That is one of the exceptions. The other one is where it relates to publicity and reputation of the employee. For instance, you are a media practitioner, so the job relates to your publicity. It relates to your reputation as a media practitioner. So under that kind of circumstance, he is bound to provide the work, and then if he doesn't provide the work, You understand? He is bound to pay the remuneration under the circumstance. And then where the work is of a particular nature, such as playing a leading role in a musical concert, a footballer and boxer, or where the employee is expected to learn on the job, he is bound to provide work for you to do. And now where the employee is a commissioned worker and the employer has a duty to ensure that he earns his commission or fees, where he doesn't do, so the employee is entitled to an action for damages. He has to provide the work. I want you to differentiate between the two. In this one, he has called you to work. By 7 o'clock, you come and sit down and you are joking. You are not doing anything. Yeah. He is entitled to pay you. You didn't do any work. But where it falls under one of these circumstances, he is bound to provide the work. For instance, you are learning as a footballer, you are learning computer under any remuneration circumstance, he is bound to provide the work. Now, where the practice makes perfect, where practice has to make perfect, the employee requires work to gain the experience. You understand? And develop his skills, he is entitled to be provided with the work. And then where the employee is employed is in an agricultural undertaking, and his payment is based on his output, he is bound to be provided work. All these are provided for under Section 17 of the Labour Act. The next duty is to pay remuneration. We have already subsumed that. He has to pay remuneration. He is expected to pay, like in the case of Egbe and Midwest Development Company, where the man did not complete the work. The law expects you to pay what we call quantum merit, according to what work was done. Supposing if he was supposed to mold 50 wraps of fufu, he ended up molding 20 wraps of fufu. The employer has to pay him for 20 wraps of fufu. As in, we will now calculate 50 wraps was supposed to be 5,000 for the day. Now he has done 20. That is 40%. So we give him 40% of the 5,000, which we will know is 2,000 naira. That's what we call quantum merit. And now, another duty of an employer is to indemnify where an employee incurs expenses, losses, and liabilities in the course of his employment. The employer is bound to indemnify him. Where the employee incurs losses in the process of his employment, the employer is bound to indemnify him. What are we looking at? Okay. We are looking at a situation where in the course of the employment, we say the employee committed a tort. Yeah. And that is an aspect of saying, when we're talking about, I think we discussed that on this day, we're talking about limiting employers' liability for the torts committed by their servants. But now, if he was in the course of the master's job and he ended up pouring somebody's oil, it is the duty of the master to pay for the oil. If he was set on the master's job, go and bring the children from school, and then due to no fault of his, or maybe they skid in the vehicle, which is as a result of the fault of the vehicle, which was noticed, for instance, and then the master had told him, when you come back, we'll take the car to the mechanic. And then in the process, the tire break and he hit one machine, you understand, and it results in damages. It is the employer that is to indemnify. When we mean by indemnifying, it means he is the one to take the place of the employee in the payment of damages. Okay. So that's another duty of the employer in the circumstance. Then we have duty to give references and testimonials. The man may have worked for him for 5 years and needs to go into another job, and then they now ask him, what this barrister will say, how did he perform in your organization? He has a duty to give that reference and testimony, not as in Hedley Bain and Heller and Partners, where they say that when you give a reference that is untrue, you will be bound by it. Yes, now we look at the duty to train the employee. Like when we're talking about the contract of apprenticeship, it is the duty of the employer to train the employee in a duty of apprenticeship. So those are the few duties of the employer to the employee. We have talked about the duty to provide work. We have talked about the duty to pay remuneration. We have talked about the duty to indemnify. We We have talked about the duty to give reference and testimonials in the case another company wants such reference and testimonials. And then we have talked about the duty to train the employee. Then when it comes to the duties of the employee to the employer, we look at the duty to obey reasonable orders. So the first known obligation which an employee owes an employer is the duty to obey reasonable and lawful orders. Reasonable and lawful orders. For instance, a media practitioner knows what for instance, if it is go and perform administrative duties, it will look at in the eyes of the law. Are those the reasonable and lawful orders to an information officer or a media practitioner? The media practitioner, one of them is to sit on set. So go and interview Barrister Kenneth and you refuse. The law says you can be dismissed summarily. So that is it. The next is to duty to exercise care and skill. The employee now is to exercise care and skill in the process. Yes, in the performance of his duties. And that duty of care and skill is very important. Then we have a duty to keep trade secrets and confidential information while in employment.
Yeah.
And this normally leads to what we call trade restraints, contracts in restraint of trade. For instance, if the man worked and there is a particular way they used to go about their media practice, which has been earning them patronage, and the man has worked, and then one of the terms of the employment is that when you leave the employment, you will not go and tell the other employer how we went about getting our customers. You understand?
Yes.
So that duty will remain until the employer leaves that employment. You understand? And then the employer may have agreed with the employee that when you leave within 100 kilometers of 34 Ambo, you will not set up a media outfit. You understand? That is what we call a contract in restraint of trade. But the attitude of the court has always been that such trade restraints are unenforceable. That the man can come out and stay at the Semikaika and open a media outfit, provided he is not working under your employment, he had resigned, or you had terminated his appointment. That trade restraint ceases to exist upon the time he tenders resignation. Yeah. So another duty is duty to render faithful service. And this is the one that we are going to dwell a little more on. You see, when we talk about faithful service, we are talking about a situation where you go back and render account of your stewardship. Faithful service means that if you went out and then you made a secret profit, your employer is entitled to that secret profit. And you know, when we want to talk about it under okay.
Yeah, sorry, I wanted to bring you back to the secret profits.
Yes.
How is the employer supposed to know about these secret profits? Because sometimes based on the organization or based on your working environment, sometimes the employee might tend to, for example, let me say I sell materials and then I have my workers there, and then the cost price of this material a yard is say 1,000 naira.
Yeah.
That is the cost price I have given to them, and say, and the profit, of course,
yes,
is
embedded. It's embedded. Yeah.
So now, my employee decide, maybe I was not around. My employee decide to sell that particular material for 1,200 naira in your absence. In your absence, yes. Is the employee supposed to keep this particular 200 that has been talked to the money for the employer?
That's a serious one, but we are going to answer
yes,
you. That's a very serious one. Now let us talk about when we talked about the rendering of the faithful service.
Yes.
I think it's embedded in the making of the secret profit. Now let us differentiate them. Number one, when we talk about rendering of faithful service, we are looking at a situation where you are not working for more than one employer. For instance, Joy Dambo is working in Star Cross Television, and the next day we are hearing Joy Dambo in Radio Cross River. You are working for more than one employer. You understand? So you have breached the duty of rendering faithful service. And that is why under the public service, under government service, you cannot take up more than one pensionable appointment. One pensionable appointment. You can only hold one pensionable appointment at a time. That is the faithful and service that we are talking about. But when it comes to secret profit, what you have now spoken about is very germane. You have raised a very serious issue. If you gave your employer, let's get it right here.
Yeah.
If you gave your employer 1,000 naira per white material to sell, and your employee can sell, if you gave your employee the cost price of 1,000 naira per material, per yard of a material, and your employee can talk to your customers and sell that same material at 1,200 naira or 1,500 naira, that does not fall under secret profit. Okay. It doesn't fall under secret profit. When we talk about secret profit, it is when you now represent to the buyer that you are the owner of the business, and in the process you now reap a profit. I am going to give you a case to help you. Now let us look at the case of Reading against Attorney General, 1951, appeal cases. That AC, we call it appeal 617. Now here, a sergeant in the British Army serving in Egypt held smugglers through a checkpoint, implying that he had authority to do so without being checked. He was representing the British government, and he held smugglers at the Egyptian border. Now look at it. He was subsequently discovered due to affluent lifestyle. His bank account swelled. Those people paid him bribe, so he stuffed it in his bank. The Crown impounded the money in his bank account. In an action to recover the money, the House of Lords, that is the Supreme Court, is equivalent of the Supreme Court of Nigeria. The House of Lords held that any position that enabled a servant to earn money also gave the master the right to receive the money. So earned, even though it was earned in a criminal act. Remember, smugglers wanted to pass. A British Army official blocked them. In the process, it led to receiving so much. And then, all of a sudden, we realized that this man was earning 30 pounds. But is now buying a car, a Jaguar Nana, of 110,000 pounds. So, in the process, we need to know how you got the source of the money.
What if he has a side hustle?
Yes, that he will have brought it before the court, but it was discovered that it was standing at this border that made him so rich. So the House of Law, which is equivalent of the Supreme Court of Nigeria, now held that in as much as he had done this business, it was criminal, but all that money should go to the Crown.
Wow.
Yes, so that is when we talk about secret profit.
And there is nothing like let's return the money, to be faithful as well.
Yeah, the British Crown took it.
That is what
happened. That is what happened. But in good circumstances, what should have happened is what you have just said. The British Crown could have said, let us return the money to the smugglers. But don't forget that it was an illegal setting. Everybody was illegal.
So why are they receiving the money if it's illegal?
Because the man was acting as a servant of the British Crown. And so since they cannot go after the smugglers who may not have been named, remember it was a bribery situation where I gave and left. So I may not have been able to be traced.
There is no contract, nothing has been signed.
It's signed between us to say that, okay, that money was received from Joy Dambo. So under the circumstance, what do we do? Instead of us to allow Barrister Osim to go with the money, since he acted, on our behalf, so he did that on our behalf. So just take the money.
Okay.
Yes. So now, when it comes to that duty of not making secret profit, he must render account of all monies and properties received in the course of employment. And in that topic, when it comes to this legal education and evangelistic program, I had always said, when you are working for the Father, remember this program is, it has 60% is, to bring people to the accurate knowledge of truth or how to relate with God. So we had always said that when you are working for the Father, and then in the process, you make a secret profit, please, whichever way you can render that secret profit to the Father, do so. You understand? You went out and then cement was, captured at 10,000 naira, and then you got to a depot and they said they are going to sell the same cement for 5,000 naira. Please, either you buy the cement times 2 to represent the cost of what the Father gave you, or you come back and tell the Father, please, I bought at 5,000, this is your change. Let it be the Father that will use it, man, and say, go with it. you have rendered that secret profit. Because when you render that account, we had always said that you will be sentencing yourself to death by your own words when you tell a lie, because the Father is a quickening spirit. He goes around the universe as a quickening spirit. So when you were bargaining for that cement at 5,000 naira per bar, the Father saw you. He was there with you. And then when he comes, he just laughs at you and says, this cement these days, I heard it's 10,000. Now he said, no, Father, I bought it 5,000. You have exculpated yourself. But if you say, yes, Father, it's even 12,000, you have aggravated the situation. You have sentenced yourself to death. So that is why when it comes to topic like this, we try to, you understand, make you realize. Now, if you are working for the Father, rendering of faithful service, and then some people outside are calling you to get information from you, you are closest to the Father, that is very dangerous, because you are not rendering faithful service to the Father under the circumstance, because there are people that are also calling you to gather information from you as to how did this and this and this in the kingdom of brotherhood happen, and you were closest to that information and you gave it out. That is not rendering of faithful service. And for me to end on that topic, on that issue, on that question, remember that says, God is not mocked. For whatsoever a man sows, that he shall reap. So by the time you don't render faithful service, don't expect faithful reward, because you had sowed an unfaithful service. Definitely, it is an unfaithful reward that comes your way.
Thank you very much.
Yes.
Thank you so much, Barrister Kenneth and Barrister Sim. Yes, beloved audience, if you are just joining us, this is the Regnum Legal Education and Evangelistic Program, and we are talking about an appraisal of the determination of contract of employment, when it has to do with employment, employee and employers, contract, and all of that with employment. Whatever it is, contract and employment, whatever it is that we are discussing this night, it has to do with workers, those that employ, those that go on contract. That is what we are discussing here. So if you have missed out, it's never too late. You can always go back to our YouTube channel to watch from the beginning, so you can always have your grounds and your rights to know whenever you want to go into contract with someone. So long as whatever it is you're doing is illegal, it cannot and can never be taken to court until it is legal. So yes, you can keep watching. This is not over yet, but before that, let's take a short break, a brief one. Don't go anywhere. We shall be right back. Stay tuned. This is still the Regnum program.
Let me hear you say Star Cross.
This is to remind the general public that VCS Star Cross Television still offers the following video coverages and services: child blessings, traditional marriages, marriage blessings, birthday celebrations, send forth ceremonies, unveiling of projects, celebration of life events, anniversaries, launchings, inaugurations, end of year celebrations of various fellowships and bodies, music videos, film productions, and lots more. You can get a standard production for any of the above at a very affordable rate here at Star Cross Television. Kindly call the following numbers for bookings and further enquiries: +23470 4554 1089 or +23480 9473 5538. Management, BCS Star Cross Television. Announcer.
you so much, beloved audience, for staying tuned, and thank you for not changing your channel yet. Of course, we are not done with the program, so yes, you can't go anywhere. It is not over until it is over. I'm still here in the studio with Barrister Kenneth and Barrister Osim. We are discussing legal matters, and this time around we're talking about contracts, appraisal, and of course employment. So yes, I would like to go into the next question. I would ask Barrister Osim would be the ways, the ways known to the law that a contract of employment can be determined.
Yes, we thank you so much for that question. I used to say, let me start by saying, whatsoever has a beginning must have an end.
Okay.
So the same thing is applicable to contract. Where you have a contract, the beginning of a contract, there must surely be a time that such a contract will come to an end. Now, in contract for employment or contract generally, there are 4 ways by which this contract can be determined. 1, we have by operation of law or lapse of time. 2, we have by dismissal. 3, we have by termination. And then 4, by death. Now let me explain them briefly. By operation of law stroke lapse of time, that is when a subsequent legal event occurs which is recognized by law that makes the contract impossible to be operated or executed, then the contract may be determined. That is to say, for instance, government policy may come up to say a certain ministry or a certain company will cease from existence. And when such is done, you see that that contract automatically comes to an end. Like for instance, when we're having the NITEL, you see at a point when we have other communication media, you see that NITEL became moribund. And in that, the contract ceased. And then the workers of that employment became jobless. And also retirement, when you have the age limit of a person who is working or a worker, when his age comes to the end of the, the limit time, you see that that contract, that person too, can no longer function. And that contract now comes to an end on his own part. Then we also talk of dismissal. Dismissal is a kind of misconduct when a worker commits misconduct in an office or while performing his or her duty, he or she may be dismissed. And that is also provided for in Public Service Rule Section 4. That is, such habit like falsification of figures, stealing and all that constitute what will make an employee to be dismissed from work. So then we also have by termination. By termination, that is, in some cases, there will be a notice given to the worker or the employee to terminate such an employment. And then also there is payment of money in lieu of that notice. At times you may not want to give a 1-month notice to say, take this, you are giving a 1-month notice to your employee to terminate his appointment, his or appointment. But you can also give such an employee amount of money for 1 month, maybe 1 month remuneration, to now send the person off by terminating. Then also, it is tried law that where the employment is for a fixed period, you cannot just terminate that employment until that period elapses. So if you are to do that at all, then you have to pay the person compensation covering that period that is remaining. Then the last one, which is by death, this one is natural. When an employee an employer dies, then the company or the employment will cease to exist. Now, when you talk of the death of a company, how does a company dies, or how does an employer dies? You know, a company can die when it is one up, that is no more in existence, or if the company could no longer pay salaries to the staff, or when the company is under how do they call it, liquidation. So when such happens, then you see that that company has ceased to exist. It is dead naturally. Then for the employee, when you die, by the time you die, you are no more in existence. So that employment can no longer go on. Or when you are incapacitated, you may be still alive, but you cannot function again. You cannot go and perform your duties again. So that will also be an option for you to leave the job, which means you are dead, even though you are still alive.
Okay, so me, what I would want to ask now, it's pertaining contracts. Yeah, a situation whereby maybe a particular person, you sign a contract with a particular person for a job, and this job has been done, I mean, to a conclusion, and then this person dies. What happens to the employee for the contract dies, maybe after finishing or maybe close to finishing the job, because maybe it was supposed to be paid after the job is done, and then God forbid something happens to the employee and he dies. What happens to the salary or the money that is supposed to be paid to this person? Does the company keep the money, or they pay it to a relative of this person?
Yes, you've even answered the question.
No,
if you are in the employment,
because what if they don't know? Maybe the family members do not know about this particular contract.
Okay, let me come to that, and after that, my colleague too will join. Will lend his voice.
Yeah.
You know, in an employment, you have forms you fill.
Okay.
Like when we talk about accepting the Section 8 of Labor Act, which stipulate that the employee should accept employment by undergoing medical examination and others. So now you have to also fill a form, and this form, the next of kin will be there, your family, your wife, all those kind of things will be there. So now, if you have completed the job, or while in the employment you die, then your beneficiaries or next of kin will be the ones now to fall back to that and get that money. Then if it is an employment that, like you rightly said, that along the line you did not complete the job and you die, now the money that will be paid to either your beneficiary or whoever will be paid in quantum merit. That is to say, the part that you have worked for will be paid to your beneficiaries.
Now, my point now is a situation whereby I go for this contract, and I did not tell any of my family members that I'm going for this particular job, and I go there and I fill the forms, and maybe the employer knows that my family is not aware, but I have the details, the information of my next of kin in this particular document. And then something happens, because I'm talking about the part where Kenneth made mention of faithful service. And then something happens to me along the line after finishing my job, and the family is not aware of this particular contract. Will the employer be faithful enough to carry that money?
Okay, let me still come there.
Yes.
In practice, what you are saying is impossible for an employer to do. Okay. Because why I'm saying so, even today now, when you have you are somebody who was your breadwinner and you are a next of kin and other, if that person is no more, and then by the time you now goes to even apply to the probate, if there was no will, no written will, you know, whenever the person dies intestate, there's no will at all. You have to now apply to the high court, to the probate court, probate registry of that state. Now, when you try doing that, You may apply, you go there, fill form, you this. The frustration that you are going to encounter.
Because they don't want to give you that
yes.
money.
Now, not to even talk of when nobody is even going there to follow it up. Then you see that they may even keep quiet, and at the end of the
so
day.
So at this point, you can't sue. You can't sue anybody.
Well, to my mind.
So if you are aware, if you are in relation to the person, and because you said if the relations are not aware, you are no more, so you cannot sue. But if your relations are aware, they are the ones that have the right to sue and get it.
To my mind, I have heard everything you said, but to my mind, I want to look at it from a very different standpoint.
Okay.
In fact, I'm going to look at it from two standpoints. First, I will look at this employee dying in active service. The man was actually in the ship going to, he's a maritime worker. He's actually in the ship going to UK. He dies. The man was actually on top of the roof, roofing the house. He fell from that roof and died. That is what we call death in active service. It is one of the ways of terminating an employment. But when the staff or the worker dies in active service, it spells a very different course of action from when the worker died in the circumstance which you pointed out. Now, under the public service rules, you will find out that the law makes it that when a worker dies in active service, it is the government or the employer that provides the burial, that takes the burial expenses and pays the terminal benefit, provided that worker appointment was confirmed in the pensionable establishment. His employment was confirmed in the pensionable establishment, and confirmation in the pensionable establishment only goes after 2 years of service. Now, the man is a maritime worker, he's working in Nigerian Navy, and they are going to UK, and then the ship sank, just like the last one, the submarine submersible that sank. Supposing it was, there was a worker of that company, you understand? Supposing a worker of that company was inside that vessel, and it sank, and the man was just employed 2 days ago. Number one, the news of the death, news of the death of that person is first and foremost is in the public domain. Because when I read that news, the 5 names were mentioned. Are you understanding me? So now, when that 5 names are mentioned, it means that it is already in the public domain that so and so person are dead. So then, in that case, it is glaring that the staff that was just employed yesterday by that company is dead. So you cannot even cover it up. But I also know, let's assume that the man traveled, left the family, went to stay in Lagos, and in the process got a job with Lagos State Ministry of Information, for instance, and started working, and the wife and children are in Uyo or in Cross River, and never knew that the man had gotten a job. And eventually his appointment was confirmed. Do you understand? It is the duty of that office to inform the deceased relative that, look, your brother worked with us, is late, and then we are returning him back to you for burial. It is the duty of that office. So a staff in that office, probably in the pension unit, will get in contact with the family by the authority of management of that office. So when it comes to the pensionable establishment, it is different. The way you are going depends on the private companies who are only out to maximize profits. So in that kind of circumstance, something can be done, as in cross out the name, make it look as if we had fired him the day before, things like that. That is when that comes in. Let's make it look as if we have fired him the day before or 2 weeks before his death. And so whatever we have to give him, let it just look as if we are sympathizers. Yes, sympathizers, not compensating anymore. Sympathizers. Let it just look as if we are sympathizers. So that works most in small businesses, because even the people that have the rules book, like companies like Mobile Shell, the same thing is applicable. They have to contact the deceased relative and pay all the benefits to such relative.
In the situation she painted.
Yes, in this
the person did not even let the
family to know. I am telling you that where there is an established system, it is the duty of the employer to inform the deceased relative. I still insist. And I was trying to point out that it is only where the business is a small business where, you know, the sole ownership. I am the sole owner, I'm the sole proprietor of the company.
Yeah.
And I know that the entire burial will be on my head. For instance, the person went to teach for a private school in Lagos, and then the person dies, and the man, the sole proprietor, makes it look as if he had left the employment maybe a day before he's dead, or even on that day, that it was on his way home that he died. You understand? That is only where he can escape liability. But then, because this person has to be put in a mortuary, he still has a duty to inform the deceased relative that their son is late, and then maybe at least give a little assistance for his burial.
Okay.
Yes.
Thank you very
So now,
much.
when it comes to the other aspect, dismissal, he has talking about operation of law.
Yes,
when the man has reached 60 years, he's leaving, he's retiring, and all that, and then when the company is also retiring, the company is no longer in existence, it's under liquidation, the company has gone bankrupt.
Yes.
All this will bring the terms of employment to a close by operation of law. But let us look at the situation where the person is dismissed.
Yeah, I wanted to ask.
Dismissal denotes a disciplinary action. It's a disciplinary procedure. Dismissal is a disciplinary measure on the part of the employer of labor in bringing an end to the contract of employment. We are looking at a situation where the man has committed an offense. Like he has mentioned chapter 4 of the public service rules. The thing has now moved to chapter 10 under the public service rules 2021. It is now under chapter 10. That is when you have the rules, the offenses you commit and you go into retirement, and the offenses that you commit and you go into dismissal. You understand? One of them is financial embarrassment, where some people will go and borrow money and be guarantors. They are the ones that borrow the money. They are still the guarantors. When they now call, if I call Barrister Osim, for instance, come and borrow me 10 million, and then Barrister Osim will borrow the 10 million and hand over to me, while I will only simply issue you with a check and say, I am the guarantor. And then maybe Barrister Osim is now arrested and taken to the police station and tortured a little, and he said, please don't flog me again. I only collected the money for Barrister Kenneth. And then he can bring a little document to show that after I collected the money, after I signed guarantorship for that money, that he handed over that money to me. You understand? If it is in the public service, we see that as financial embarrassment. Harassment, there are a lot of other things that make up this disciplinary measure. Stealing, falsification of records, the man is 80 years and he says he's 20. You understand? By the time all these things come to the fore of the government, a panel is set up. And then under that panel, they will recommend dismissal. When that dismissal is recommended, it is a disciplinary measure on the part, and the effect of it is that the man loses everything. As in, the man is under a disciplinary measure. And if we want to go into the Bible, one of us, when we were working for God, had that kind of situation. Because we always have to marry this with the word of God. We find out that Moses had that problem. God dismissed him. You understand? When he came and then he broke this thing, they said, okay, go and hit the rock once. Then he hit the rock twice. Water came out. You see, when God wanted to dismiss him, a panel was set for him, even if it was not physical. And those things were recorded against him. And that was why if you go now come to Galatians Gospel, he said that rock that he hit was Christ. You see, that was an allegation that you actually hit Christ on the head. You understand? Because they said, hit the rock once. And he actually did, because of anger, hit the rock twice. And then when we went to Galatians Gospel, he said that rock was Christ. And so God told Moses, see Canaan, you will not enter. And then if you read down, you will find out that Moses died without entering that Canaan. Yeah. So if you marry it to what we are talking about, there was a disciplinary measure for his anger, and God gave his judgment. You understand? If you read it, you will find out it's tantamount to what happens in today's service, where they now say the man stole the tools that were used to be for drilling of oil. A panel is set up, he is found guilty, and then he is dismissed. That means that even if he has served 29 years in that service, remaining 1 year for him to retire, he will go back home empty-handed. He will not be paid anything because he is under a disciplinary measure. Then another one is when we talk about termination. Termination is for any reason or for no reason. Sorry, before I end, I think when we're talking about public service contract, I have the case of Iderima against River State Civil Service Commission. That was when a staff was dismissed for abandoning his duty post for about 2 years. And when he came back, it was, this appointment he was dismissed of his appointment. Then when we want to talk about termination is very easy. It can be for any reason or for no reason. If it is for any reason, you see, when you are drafting the termination, the letter of termination, you don't state the reason why you are terminating. You only say services no longer required, because under that clause, it is for any reason or for no reason. But under the public service rules, there are a lot of offenses that the person, like habitual late coming, that one will lead to termination. They say terminate. You don't dismiss him. You will give him testimonial that he has served the company for 10 years, but your services are no longer required. So that is for that one. So, and there are some cases that I have to back up, which is Nigerian Post Authority against Banjo, 1973 Supreme Court, 175. Even when the contract provides for the right to terminate at any time without notice, the law expects that reasonable notice should be given. So you cannot just tell the man go. You have to give him 1 month notice, or give him salary like he rightly mentioned, or salary in lieu of notice for the 1 month. For instance, if his salary is 400,000, by the time you give him the letter of termination, you also have to add the letter of 1 month salary.
Yeah. So what actually happens to someone who is wrongly dismissed, to an employee who is wrongly dismissed?
An employee who is wrongly dismissed will go to court.
Okay.
There is the Nigerian Labour Court. There is the Labour Court, National Industrial Court of Nigeria, that the person goes to. And the first remedy that will be given by that court is reinstatement.
Okay.
He will be reinstated and paid damages and paid the arrears of his salary. If that termination was wrongful. When it comes to wrongful termination, even wrongful dismissal, if at the end of the day, the man can go to court and prove before that court that he was not the one that stole that money, he was not the one that carried that equipment, if he can have such evidence, and if he can even show that it was constructive deployment that was meted on him. They don't want, the people there don't like you, and so they frame you up to send you away. We call that constructive. So if you can go to court to prove that, the first order that court will make is reinstatement first, and then the second order they will make is payment of damages, exemplary damages, aggravated damages, and then payment of all arrears of your salary. So that is what happens in that kind of circumstances.
All right, thank you so much. I think we have exhausted all our questions for today concerning this topic. But briefly before we go, I would also like to hear, of course, we always have, this is it's also an evangelistic program, so let us also hear from Father's teachings concerning this kind of issues being brought up, in any gathering at all. So, Barrister Osim, what's your take on it before we go?
My take on that is that Father has been teaching us on how to treat both our employers and our employees. Because Father himself, he do employ us, even as preachers.
Yeah.
He treated us very well. He treats us very well. He send us to stations. And then if any station does not comply with what should be done to a priest, Father will also give some remedies. Then also, even Father has told us, in his gospel, we should always be sincere. We should be like these faithful services he has taught us all that. So, and the bone of contention of all this is to love. Whatsoever you are doing, you apply love in it. Like now, if you are working, if you are an employer, and then you employ somebody to work under you, with that love, you believe that if me, I am living like this, these are the things I want for myself, the achievement. You also want to do same unto your employees. So when you exercise this love, and then you treat your workers like the way you should, because you know these are the people that are bringing the goodies. They are the ones that are working to expand their business.
Yeah.
And you see that at the end of the day, there will be no issue of resorting to going to court or whatsoever. Thank you.
Thank you very much, Barrister Osim. Barrister Kenneth, do you also agree on the saying that says don't practice or don't preach what you cannot practice? Do you agree
when
with
it
that?
when it comes to the topic on hand, I think one of the teachings of the Father is that he that will not walk, let him not eat.
Okay.
And that the idle mind is the devil's
workshop.
the devil's tool. I
Okay.
call the devil's tool.
Okay.
So if you are a member of Brotherhood of the Cross and Star, the first thing is that no matter how small, the days of humble beginnings, you understand? So many of us, I'm sure all of us here have stories to tell when it comes to humble beginnings. So you start small, or no matter how small that thing is, and then if eventually you get to the point where you get into an employment, be an example in that establishment. You understand? For instance, some of us, when it comes to forgery, when it comes to stealing, when it comes to corruption, they will say that is a member of Brotherhood, who don't take it before him. And that is simply because they have watched you and realized that you are not part, you are not interested in all those things, but to render the faithful service that we are talking about. And now, if you are an employer of labor and you are a Brotherhood person, let your company be that of an example. Let it be the kind of company that will make those that have worked with you to go out and prosper, rather than go and work and then at the end of the day they go to steal banana to break their fast. You understand? Let that example be there, that at the end of the day you have made profit of over 200%, and then you have decided to use 50% to make those people that you use in getting that reward. You know, you make sure that it gets back to them. You understand? Maybe by, even if it is 1,000 naira, even if it is by a party, even if it is just by recognizing the fact that we will not be here today if not for Mr. XYZ, who has put in so much to ensure that we are here. You understand? Let it not be a situation that, you know, this man knows that you are a Brotherhood member, and then you are running a business. At the end of the day, he helped you secure a contract, he even helped you get payment for the contract. But at the end of the day, when you collected the entire money, it becomes a personal issue. Do you know how I started in this business? Is it because you have gone to connect one contract and you put everything in your pocket? It's not a good example. Those are some of the teachings of the Father. Like he really said, it's because you love that your worker. You know that when he goes back home also, his children will cry for bread. So you should also be able to buy bread and take home. So those are some of the teachings. And then don't just sit back at home and believe that manna will come from heaven. Go out and walk.
Thank you so much. Thank you so much.
Use your hands and walking.
Just when we are wrapping up, we are already out of time. We're so sorry, we're working with time here. Please, next time, call us early, call us on time when you see us on the program. We are very much grateful to all of you that have stayed on to the from the beginning of this program till now that we have concluded. It's a very interesting topic, of course. So if you missed out on our discussion today, you can always go back to our YouTube channel to watch the program again and drop your question there as well. Then when we come back again on our next segment, we can always treat it. And whoever is calling us, please kindly drop your question as well on our YouTube. Sorry, we are out of time. We can't attend to your call now. Please, we sincerely apologize. And thank you so much to all those that have dropped their comments on our YouTube platform. Really appreciate you. See you again some other Friday. For now, remain blessed. My name is Joy Dambo, and of course, Barrister Kenneth and Barrister Osim today were, and of course, were my guests. Thank you so much. Bye. Television, God.